Good morning and welcome everyone to the 14th meeting of the Culture, Tourism, Europe and External Affairs Committee and our 5th remote meeting. We also have apologies today from Ros Greer MSP, however I'm pleased to welcome Patrick Harvey MSP to the committee as a substitute for Ros today. Our main item of business this morning is an evidence session on the future relationship negotiations between the European Union and the UK Government. Today's session will focus on 3 key areas of the negotiations, namely fisheries, level playing field conditions and financial services. Can I welcome to the meeting our expert panel of witnesses, and can I thank you all for taking the time to give evidence today. Professor Sarah Hall, who is Professor of Economic Geography at the Faculty of Social Sciences and at the University of Nottingham. Elspeth MacDonald, Chief Executive Officer for the Scottish Fishermen's Federation, and Ali Renison, the Head of EU and Trade Policy at the Institute of Directors. Thank you very much for joining us. Before we move to questions, I'd like to remind everyone that because of the challenges of managing a virtual meeting such as this, we're going to take questions in a pre-arranged order. I understand that Elspeth needs to leave the meeting early, so the committee has agreed to start with questions about fisheries if possible. As always, I would be grateful if questions and answers could be kept as succinct as possible, and I would remind members to give broadcasting staff a few seconds to operate your microphones before beginning to ask your question or indeed to provide an answer. I will begin with the first question, to be followed by the Deputy Convener, Claire Baker. And I'd like to talk about financial services and address my question to Professor Hall and indeed Ali Renison if she wishes to answer this. I understand that from Professor Hall's paper that the UK has more or less accepted that it will be treated as a third country for financial services and has moved away from automatic equivalence demands. You mentioned, Professor Hall, of a recent estimate of 320 financial services companies in the UK who have already begun moving staff and assets to European countries. And you mentioned Dublin, Frankfurt, Luxembourg, Amsterdam and Paris as cities which have been benefiting from relocations to date. So I wondered if you were able to answer whether you could outline the main drivers that are forcing UK financial services to relocate out of the UK. What are the main areas of financial services that are moving people and assets out of the UK? And is it possible to estimate the financial scale of assets being moved out of the UK?
Thank you very much. The main driver, I think, for financial firms relocating out of the UK is the ending of passporting arrangements that financial firms in the UK currently use as the UK is a member of the single market during transition to access EU markets. This basically means that if you're a bank based in Edinburgh, you can service clients in Frankfurt from your Edinburgh base without additional need for regulatory clearance. And it also allows you to construct a banking network across the EU from your UK base. And this is important because typically a client of a financial firm will want to use a range of your financial services. They might want advice on access to capital. They might want to foreign exchange expertise, for example. When the UK leaves the transition period at the end of this year, the UK will be reliant on equivalence arrangements, which don't allow this automatic recognition of regulatory equivalence between the UK and the EU. So because of the risks involved around equivalence, which I can speak to later if you'd like me to, it makes sense from a corporate point of view for parts of banking firms in particular to be relocated into the EU member states to continue single market access.
Okay, thanks very much. I would appreciate it if you could maybe talk a little bit about the risks of equivalence and the UK being treated as a third country in that respect. But I also note that you gave examples of Scottish financial services firms that have moved, namely the Standard Life in Aberdeen, which has opened a portfolio management and distribution service in Dublin, and the Royal Bank of Scotland, which began operating a banking entity in the Netherlands. Are you able to say any more about what impact this could have on the financial services sector in Scotland? And are there any particular areas of financial services in Scotland or where Scotland has strengths that are likely to be affected if the UK is treated as a third country?
So the critical thing about how the end of passporting and of the move to equivalence works is that it affects different parts of financial services differently. So banking in particular benefits significantly from passporting, but equivalence doesn't go nearly so far in terms of access to EU markets. So sort of the Edinburgh in particular strengths around banking, and that's one of the examples that I gave in the evidence. You know, for those institutions, it would make sense from a corporate strategy point of view to relocate, and we're seeing a concentration of those relocations, particularly in Frankfurt. I think the other area that, by my understanding, Scotland has particular strengths is the asset management industry in Edinburgh. We have seen some moves of asset management firms to the EU, but also some parts of asset management have been concerned about additional regulatory costs for the EU, and so potentially see the opportunity for regulatory divergence from the EU to stimulate asset management business in Scotland and the rest of the UK.
Thank you very much. That's very interesting and indeed worrying, and I hope I'll be able to explore it more later. But the challenges of the virtual committee meeting means that I'm going to stick to my 2 questions and move on to Deputy Convener Claire Baker.
Thank you, Convener. I'd be interested in the panel's views about the need for an extension. We are obviously now some 6 months away from the point at which the deal is meant to be concluded and we're into the next phase. And concerns have been expressed about the very short timescale we're facing, and there are increasing calls for an extension. Do the panel have views on the advantages or disadvantage of an extension? Ali, did you want to?
I think I'll pick that up. I presume everyone can hear me. I just want to make sure I'm off mute. I think it's important to distinguish what, at least from a business perspective, the need for more time, so to speak, is, because I think there are a lot of businesses who see the discussion around transition extension much as an extension, if I'm honest, of the Brexit discussion itself. And so there's some, most businesses do not want to get pulled into the politics of whether there's a need for more time in the context of the negotiations. I think it's important to distinguish that. That's a political element. From a business perspective, I think the biggest concern is making sure that there is enough time left to adjust once there's clarity over what the changes are or aren't. And that's, there has been much talk about having a standard trade agreement. I think it's important to reflect on when we look at other standard trade agreements, even ones that the EU has. There is inevitably, even though it's not specifically referred to as an implementation phase or an adjustment period, there is one of those inevitably because they have a status quo to rely on if the negotiations don't go well. And so it's normal, in addition to having, I think the biggest concern that businesses have is when is the text or clarity of what the change is going to be, because we could either have a deal or we could not have a deal. And while there is some clarity in the withdrawal agreement to fall back on, that's quite a big series of moving targets to plan for, particularly this far out. So I think it's important to distinguish between the way in which this gets done and the need for, from an implementation perspective, what firms actually are requiring. At the moment, for example, in the agri-food space, things are changing on a day-to-day basis. The way in which supply chains work have been completely significantly, I wouldn't say overhauled, but they have certainly been impacted day in, day out since March. And so they're in and amidst all of these changes, I think it's very difficult for businesses now to know what state of play they're going to be in with their suppliers and their customers, particularly since countries in the EU, from a trade perspective, are only starting, to lift the lockdown. And I think the more that the lockdowns are lifted, perhaps it becomes slightly easier to plan out 6 months in advance. But right now, I think if you look back to the last year, in the run-up to several potential no-deal dates, looking at the first one, March, there are 2, I think, examples that stand out, which reflect where we don't want to get to this time around, and why, regardless of whether it is through the extension of the transition period or a separate implementation phase, why I think there's a need for that. And you had 2 weeks before March 29th last year, businesses were only getting the detail of the proposals. They weren't procedures. They were proposals for the Irish land border in a no-deal situation, and also what the no-deal tariff schedule was going to be. And I draw on those examples simply to say that we cannot be in that position again of having that much critical information that close to the end of play. So I think the plea from businesses is that, you know, many people are the lay of the land at the moment with business from a trade perspective is pretty fluid and fluctuating. And so all I think we are trying to make sure that lawmakers and politicians on all sides understand is the need for time to adjust, because there is a there is a three-part step process I think that you would see. One is the sort of, if there is an agreement, one is the text. But if you are going to, most businesses, particularly SMEs, looking at a trade agreement text in particular, are not going to be able to make sense of what that means in practice. So that's why you have a text, and then depending on what's in it, the domestic architecture. So, for example, our customs authorities and respective customs authorities across Europe would take that text or and say, this is what it's going to look like in practice. This is how we're going to implement it. These are the actual practical procedures that arise from the text and whatever suite of side agreements there may be. And then businesses adjust to it. So I think it's important to distinguish, do businesses want the transition extended from what is the need for adjustment time and why. How that looks is up to politicians to discuss, but it's the substance behind it that I think we need to focus on, at least from a business perspective. And Sarah and Dr. Hall may have some views on what the alternative, if any, legal options would be in the absence of a transition period being extended for that purpose.
Thank you. In addition, I'll ask Sarah Hall to come in a second and to respond to that. I suppose to add into the general discussion is the impact of the coronavirus pandemic, and that has led some to feel that government's focus across the UK and the whole of Europe has been about fighting the pandemic. And where has this left the priority of the Brexit deal being agreed, and as this puts further pressure on the negotiations? If Professor Hall can respond to that and the initial question, and I'd be interested in a wee bit more expansion on the proposal that's been explained, that you have the deal and then you have a transition period and then you have an implementation phase, whether there's any legal barriers to that given the legislation that was passed that doesn't allow for an extension, if that presents any problems, or do you see that as being an agreement of the UK and the EU that that would be the sequence of events that would be supportive for business?
So on the impact of coronavirus and the question of extension, I think this does need to be seen, as Ali Renison said, as a set of economic and practical questions about how firms and businesses are able to plan for a significant change with trade with our major trading partners. So, for example, in services, the EU is the largest destination for services exports, and I don't think we should underestimate the significance of changing that relationship and the need to give businesses and individuals time to plan for that. I think on COVID, a lot's been made about the challenges of conducting the negotiations online. I think there's also a business element to this, and particularly in the sort of service sectors that I look at that rely on face-to-face interaction and interpersonal discussions, just the practicalities of implementing plans for a marked change in your trading relationship is harder if you can't meet people face-to-face. So it has, I think, impacted on the negotiations, but I think it also has very real and practical implications for how financial services firms, business services firms are able to plan and implement their own scenario planning, depending on what the outcome is. In terms of the legalities of a sort of implementation phase to a new arrangement, I'm not a legal scholar. I work quite closely with one at UK No Changing Europe, and legally it gets much harder if we don't request an extension by the end of June. It becomes that's the point legally where if the UK is seeking an extension, it should ask for an extension. That being said, my reading of the situation is that usually if there is a will to implement an extension come the autumn, where there's been quite a lot of attention recently, usually a way could be found to do that, but it's not as straightforward as in June. And I think that really builds on Ali Redison's point that as you get closer to the wire in these negotiations, the chance for mistakes or oversights to come in probably practically increases. And certainly in financial services, in the face of uncertainty, I think that's one of the drivers for firms beginning to implement parts of their kind of post-Brexit corporate strategies in terms of the locations and relocation, that I mentioned earlier.
Thank you.
Thank you. Did Elspeth, did you want to come in there on the extension?
Yes, thank you. From a fisheries perspective, we certainly do not want to see an extension to the transition period, and that is because because of the annual cycle of negotiations on fisheries between what are called coastal states. So as we approach the end of this year, the annual process by which neighbouring coastal states that share fish stocks get together to negotiate fishing opportunities and access for the year ahead that process will start with publication of scientific advice at the beginning of July, and then we'll move into a series of negotiations that will commence in October and run through towards the end of the year. So for those reasons, certainly in the fishing sector, we do not want to see an extension to the transition period, because that would essentially take us into 2021 still as part of the common fisheries policy and all the constraints and disadvantages that has for our sector. I appreciate that there are, of course, different views in other sectors, but from our perspective, we do not want to see any extension to the transition period.
That's very clear. I'll now move to Beatrice Wishart, who will be followed by Patrick Harvey.
Thank you, Convener. Good morning, colleagues, and good morning, panel. My questions are for Elspeth Donald, so I think that was well timed. We know that there's an abundance of fish in Scottish waters, and that some EU and third countries have a significant dependence on those waters for the catch. I mean, 34% of all fish landed by UK fishing boats is caught within 50 miles of Shetland. So what's the view of the Scottish Fishermen's Federation on access to UK waters by EU boats after the end of the transition period? I'm just trying to understand what the implications might be.
Thank you. What we want to see in future through a fisheries framework agreement between the EU and the UK is a very different arrangement, whereby the UK has control of access to its exclusive economic zone. That we have a much different arrangement on quota shares based on where fish actually are in waters and not on historic track record of fishing activity, and that most importantly we have annual negotiations around access and fishing opportunity. And I think we've always been clear that we have never said that EU vessels should not have access to UK waters in future, but that has to be the subject of annual negotiations. The framework of a high-level framework of which should be set out in the fisheries agreement, and that annual negotiations would negotiate the terms and conditions of access. And in that sort of arrangement, we're not seeking anything unusual. We are simply seeking the same sort of arrangement that the EU has with other neighbouring coastal states, such as Norway, for example. So I think that's an important point to make. Our position and what we are looking for out of these negotiations is not anything bespoke or unusual, but essentially a similar arrangement to what the EU has with Norway, indeed how the EU acts itself as a coastal state in terms of controlling access to its waters and its resources.
Thank you for that answer. That's obviously looking at the fish that are being caught, but there's also the other side of the market. So what would happen, if some UK fish products are no longer have a universal tariff-free and frictionless access to the EU market? How do you think the Scottish fishing industry will be affected? And which fish products do you think would be most affected? I mean, we've seen the effect of COVID on exports of mussels and shellfish, for example.
Yes, I mean, clearly, in a future trading relationship, if there were to be tariffs and non-tariff barriers in place, which is not the case now in terms of trade between the UK and the rest of the EU, then those would certainly have an impact. But I think that's why it's important that we are clear, that we separate the issues of negotiations of fishing opportunity from the wider trade agreement. And I think it's important to recognise, I think, that the trade in seafood products, for example, between the UK and the EU back to the UK is actually about the same. There's about £1 billion worth of trade in each direction. So clearly the introduction of tariffs and non-tariff barriers would apply in both directions. So it's in the interest of both parties to find a good agreement on trade. But it's very much our view that we should not give up our sovereign natural resource of our fishing waters to achieve that. And there's a good parallel, actually. Again, I draw a parallel with Norway. I attended a cross-party group meeting in the Parliament earlier this year, just not long before COVID outbreak, where the Norwegian ambassador was talking about Brexit and other issues from a Norwegian perspective. And he spoke very eloquently about how in Norway they absolutely prioritise control of access to their fisheries resource over issues of access to the market. And they recognise that they pay for access to the market through EEA membership. And would love to have a situation where they didn't have tariffs and other barriers for market access, but said giving up their fish and their ability to control their EEZ is not a price that they consider worth paying.
Yes, I was at that meeting. I remember that. Thank you.
Okay, thank you very much. Although normally we wouldn't take supplementaries because of the constraints of the technology, I know that Elspeth has to leave early, and Annabelle Ewing is interested in asking us supplementary on fish. So I'm going to bring Annabelle in now. Annabelle.
Thank you, convener, and thank you for that. I think I'm down to be the last person to ask a question this morning, so I think I probably would have missed the boat otherwise, so to speak. I would like to ask Elspeth, we have heard in previous evidence sessions that the committee has held that there is a concern that the UK government will trade away fishing interests for a deal elsewhere, including perhaps in particular on financial services. I wonder if Elspeth could indicate whether that is a view held by her membership in the SFF, that there is a risk that this could happen.
I think my membership in the SFF would always be concerned that such a thing could happen. I think there are long memories that go back to when the UK joined the EU, and the settlement that emerged through the Common Fisheries Policy was certainly not to the advantage of the UK fishing industry. And indeed, there has been commentary since then in terms of how fisheries were considered as expendable. And as I say, there are long memories in this industry, and many of the people involved then are still involved through family businesses, etc. So absolutely, there are concerns that there will be pressures coming from other sectors, bearing in mind that the value of the fishing industry is relatively small in overall terms. However, I think my members have been are reassured by the messages from the UK government in terms of them recognising the sovereign importance of controlling access to our natural resources. And Mr. Frost, the lead negotiator, was very clear when he gave evidence to the Westminster Brexit committee recently about, asked the same question, said he absolutely did not regard fisheries as something that could be traded away for anything else. So I think the government are clear in their messaging and their signalling that they do not intend to trade fisheries for something else. But I think my members will be naturally sceptical until they see the ink dry, and it's my job to make sure that we keep as much pressure on the government to make sure that they don't trade away what is a hugely valuable national resource.
Thank you very much. And I move to Patrick Harvey, followed by Oliver Mundell.
Thank you, Convener, and good morning to the panel of witnesses. On a whole host of areas, including fishing, actually, there is obviously a tension between the interests of industry and the wider public interest in terms of regulation, sustainability, and so on. But I was looking for a broader overview from the witnesses about the two negotiating positions. It seems to me that there's still a sort of media narrative around this that says the EU would prefer a closer relationship with lots of market access, but also lots of regulatory alignment. And they are basically putting to the UK a choice. Do you go high or low? Do you want a close relationship or one with a lot less market access and less regulatory alignment, but that the UK is unwilling to choose and wants lots of market access and very low regulatory alignment? Is that overview still an accurate picture of the two positions? And how realistic is it that the UK can maintain the position of having its cake and eating it? Can we maybe start with Professor Hall?
Yeah, thank you very much for that. So I would agree with the assessment that the key question really for me that the negotiations pivot on is the extent to which the UK is prepared to accept a degree of regulatory alignment in order to secure single market access. And certainly when you look at the documents as they relate to financial services, the UK is asking for more market access than would be typical in a free trade agreement. It has some elements in the draft negotiating position that the UK published, which are exactly the same as the deal the EU has with Canada. So the UK negotiating team has made quite a lot about how the UK is not asking for anything particularly special and is following the CETA, the Canada deal, or the UK-Japan deal. So I look quite closely to see, is there evidence of that? And yes, there is. There are some parts of the draft text that the UK published in May that are exactly the same as Canada. However, it's a little bit more complicated than that because in some areas the UK is asking for more. So one of the areas that it's asking for more is in relation to the mobility of individuals who hold professional qualifications, so making it easier for people like lawyers and architects to service EU markets. And the UK there is going further in its ask than is in CETA, for example. And I think in some ways the UK is asking for more market access in financial services more generally than CETA. You can see this in the structure of the deal, where the UK has a distinctive chapter on financial services in its published draft. The EU doesn't have a chapter in its published draft specifically on financial services. I think this is it's a key question because a lot of the political debate around the support for Brexit was around taking back control, taking back regulatory control. So how you deliver the degree of market access that in some areas the UK appears to be seeking whilst taking back regulatory control is difficult to reconcile, I think.
Any of the other witnesses want to comment on this?
Ali.
Winston has, yep.
Yeah, I think Dr. Hall has done a pretty good job of outlining that. I mean, this is inevitably the difficulty with reconciling or trying to reconcile the narrative and the message that's being delivered by any one side with the substance. Inevitably, the UK's history, economic, never mind political, of integration with the European bloc. So it's very hard to just ignore that, because so many jobs are, I wouldn't necessarily link to, is there has been industries that have been built up around this. So it's hard to completely, I think, jettison that and say that we are only going to look for anything standard, because inevitably to mitigate the impact, you're going to be looking for something that other countries simply don't require. So, for example, I think one of the interesting ways to look at it is on customs. We were somewhat surprised that the UK government did not choose to retain the option of aligning just on an individual piece of customs legislation, for example. So if you look at Norway, since we've been talking about Norway, after 9/11, when lots of countries, including the EU as an entity, were bringing in sort of safety and security measures post 9/11, Norway, that would have, one of the pieces of legislation required that was brought in under that, would have complicated the fairly smoothly functioning customs and trade relationship that Norway has with the EU. So Norway opted to align with that part of the EU's customs code. And we thought that that would be an obvious way to try and look at mitigating the impact of the Northern Ireland Protocol on the potential for increase in costs and paperwork in terms of trade between Great Britain and Northern Ireland. And I think there was some surprise that that option was not looked at an actual piece of alignment. And as far as I can tell, that I can't guarantee, I don't think that that necessarily opens up Norway to the European Court of Justice, although in any event, they are sort of implementing a lot of the single market rules by way of the EFTA court. But this on customs is not in that area. So that's an example, I think, of where alignment might have made sense. And I think looking at this now, it is important probably to remember that the government's position is they do not want to do any alignment. So while I think we were slightly disappointed that there wasn't a sort of more of a halfway house approach to looking at where it made sense and where it didn't, that is so we have to look at it through that context and framework. What is standard? What is not standard? Where does it make sense to actually, regardless of people's starting positions, try and go beyond what other countries have done? And I think that you will see more of that. I know that there was a question down the line about what could be done to mitigate the impact of any disruption arising from the end of negotiations. I think you'll see more of that as we get on in this negotiations, because a lot of the technical facilitation work that, for example, customs cooperation could do, it's not going to kick in until you know what the baseline of the agreement is going to be. You're not then lifting that increased border cooperation, which is what the UK is asking for. And I think that competence is actually more split between the EU Commission and the member states, but the Commission is negotiating. This became relevant last year in and around the discussion around the backstop around Northern Ireland. Could there be rural arrangements between individual member states, such as the UK and Ireland? And as we understand it, customs authorities just were not able to really engage with the UK because of the blanket focus on the Commission negotiating. So we need to see whether that sort of balance out. How do we actually find a common way to cut down on this? I mean, I think it's important to say that both sides, from as far as we can see, both sides have their own focus on sovereignty and their own legal orders. And it does seem that trade continuity and trade protection go down the totem pole for both sides. I think there is perception that in terms of the choice of prioritizing sovereignty and flexibility and control, that is just a UK ask. And I would say that that's very much the EU's ask in the same sense, because at the end of the day, UK and European businesses are both going to be looking at this as we come down to the wire and saying, well, how do we look through this in a way that does not exacerbate the problems that we already face? So I think that we'll see as the negotiations go on a little bit more balance in that respect.
Okay. I think like other members, I got most of the gist, but you were breaking up a couple of times. So obviously, if anybody wants to supplement what you've said in person, I'm sure the committee would be willing to receive anything further in writing. I just wonder if on both sides of this equation, market access and regulation, the UK is kind of painting itself into a corner. It doesn't want the full access to the single market, because from the EU's perspective, single market includes free movement of people. It doesn't want close regulatory alignment. And so it seems to me on both sides of this, the UK is painting itself into a corner of a a much less close economic relationship, wouldn't it be more honest for the UK just to come out and say that they want the most damaging Brexit?
Professor Hall?
So I go. I'm quite happy to follow that up. Oh, sorry, go ahead.
Okay. I think one thing we know is that it is hard to accurately estimate what the Brexit hit will be on the economy, but the government in 2018, when it ran analyses, was showing, for example, decreases in services output of 6% with a free trade agreement, as sort of what might be seen as a standard free trade agreement, or around 8% if we ended up trading on WTO terms. So I do think that we need to be clear that the services sector that I work on will look different either with or without a deal. And I think sometimes that can get lost in some of the discussions around other really important implications of the end of the transition period. So we hear quite a lot, for example, about issues around supply chains and goods, which are clearly important. But I do think it's important to be clear about the potential impacts across the breadth of the economy. And I think maybe more could have been and probably should be made about that. But particularly, actually, when we take into account the fact that for example, services are unevenly distributed across the UK. So a lot is made about London and financial services. But I think particularly for this committee's work, Scotland is a really significant a source of service exports to the EU, and the figures are in the Services and Brexit report that I believe was circulated along with the paperwork. So, there are places like Edinburgh that have strengths in particular types of financial services that we need to take account of, and I would suggest possibly more account of than we have today.
Thank you.
Do any of the other witnesses want to come in? I think we can move on now. Oliver Mundell.
Thank you, convener. I wanted to come back to fisheries again. Obviously, we've heard a bit about the political history of fisheries, but I wondered whether the Scottish Fishermen's Federation had a view on Scottish politicians now who are effectively pushing to keep Scottish fishermen trapped in the CFP for longer than is necessary.
Elspeth.
Thank you. Certainly, my members are not keen to be trapped in the CFP for a moment longer than is necessary, and there are a number of reasons for that, not least of which is the fact that under the CFP, the industry in Scotland is only entitled to catch less than 40% of the fish that are in our waters. So the CFP creates a real, if you like, an injustice in terms of our ability to make use of our own natural resources. So that's I think the biggest dissatisfaction that the industry has with the CFP in terms of the basing of shares of fish stocks on historical track record and of fishing patterns of the 1960s and 70s, and that have no basis in reality of where fish are today. So that, coupled with, I think, some of the very inflexible and very difficult to change regulations of the CFP, I think make life very, very difficult for the industry. We, after exit, certainly will have many of the same objectives in terms of wanting to have sustainable fish stocks for the future, to be able to manage our fisheries well, to make sure that we are managing our shared stocks with our neighbours. But we can have much better ways of doing that are more agile, that are much more rooted in the management of the sea areas that we are particularly dealing with, rather than trying to deal with the whole of the EU. So yes, there are a lot of a lot of things in the common fisheries policy that the industry finds very difficult to live with and will not be sorry to leave behind. So I think we would certainly be very keen to have politicians' support for helping us move to a situation where we will have control of access to our waters. We can determine who else can fish in our waters, what they can catch and when they can do it, and that we can have agile, well-designed management and regulatory controls in our waters that are appropriate to our fisheries, and we would certainly want to have political support for that.
Oliver.
But I can certainly say that I fully support that, and I want to see us out of the CFP and an independent coastal state as soon as possible. But I wonder, there's been a lot of speculation about fisheries in the media over recent weeks. They've become key to the negotiations, and it's just to get an assessment of any inside track you have, any wider knowledge on how likely it is to achieve a standalone agreement that allows us to do the things that you're talking about.
Well, I think it's certainly clear from the readouts from the negotiations that there are many sticking points, and the key issues where there is disagreement between the UK and the EU sides are on these absolutely critical issues of controlling access to waters and having a system of quota shares based on zonal attachments. So that's where fish are, rather than, as I say, the historic track record that the EU shares are based on. So these are big and difficult issues when both sides are very far apart. I think too the fact that the UK position is that there should be a separate standalone fisheries agreement again is some way from the EU's position of that fisheries agreement being linked to the wider trade agreement. So the political declaration set out that both sides should use their best endeavours to reach a fisheries agreement by July. I don't think that's likely to happen, but there certainly appears to be a willingness to keep going, that these negotiations should continue. But I would also make the point that if both sides can't reach agreement on a framework fisheries agreement, that will not be a barrier to us being able to have the end-year independent coastal state negotiations. There is already a legal basis for those through the UN Convention on the Law of the Sea. There's an existing legal infrastructure. There's an existing practical infrastructure in terms of the coastal state negotiations. So obviously, it would be good to have a fisheries agreement between the EU and the UK, but it has to be the right one. And if there isn't a fisheries agreement, that does not prevent the UK operating as an independent coastal state going into the end-year negotiations for next year.
Thank you very much. I'd now like to bring in Stuart McMillan.
Thank you, convener. Good morning, panel. So my first question, it's probably more directed towards Professor Hall, just regarding why the EU wants to pursue the one deal covering all the different sectors, whilst the UK government is certainly proposing the 10 different sectoral deals, because clearly that has an effect and an impact upon the level playing field discussions.
Yeah, so I'm not an expert on level playing field. I think Ali might be able to pick up on that specifically. But in terms of why the UK is looking at separate agreements and the EU wants a greater bundling, I think there's an example in financial services that possibly suggests why this might be the case, in that the UK, I think, has some concerns that decisions around things like equivalence need to and should be made on economic bases, and should, wherever possible, have wider political concerns taken out of those decisions. So equivalence decisions is what it's looking like we will be moving towards at the end of passporting. There are decisions made about the extent to which regulations between the two parties are equivalent or not, as the name suggests. The critical thing is that these decisions can currently be revoked within 30 days by the EU. So that leaves a degree of uncertainty for businesses. And the EU has undertaken such revocations in the past. Particularly, there was a notable example relatively recently in relation to Switzerland. And I think the UK is, for my reading of it, is that the UK is hoping that by keeping things separate, it somehow manages to take out some of the politics from some of those decisions which have really significant economic ramifications.
Thank you.
Did any of the other witnesses want to comment?
Please do let me know if you can't hear me. My video is sometimes going in and out. I think on the level playing field, it's important to distinguish what the argument is and what both sides are after. Because at the end of the day, while this potentially has the capacity to really wreck the negotiations, it really shouldn't, because it's hard to conceive that the UK government, whatever its stripe, would want to completely move away from the subsidy rules that it effectively has helped develop in the single market. And I think this is actually quite an important one, without wishing to go too much in a different direction for Scotland and devolved nations, devolved administrations, because we get a lot of our non-discrimination and level playing field law from the internal market. I won't go down the path of what's going to happen to the debate around when those competences come back. What is the level playing field? Where do we derive that level playing field within the UK? Is it continuing from EU obligations that provided the basis for that before, or is it going to be from the UK, but still through upholding? People are talking about potentially could have an anti-subsidy treaty. Now, I don't think we're going to get to that stage. But I do think that the EU asking effectively for the UK in perpetuity to keep adopting EU state aid rules and effectively potentially being subject to the European Court of Justice is a very big ask from the Commission, very big. And so this really should be more of an area where we talk about, because it does say that in the political declaration, even the amended one that this government agreed to, regardless of whether one focuses on its absolutely binding nature or not, as it's not, it talked about the level of those commitments being commensurate with the scale and I think the sort of depth of integration, or not integration, of cooperation between the UK and the EU. So even in the political declaration, it was envisaged that there would be this kind of flexibility of it depended on how close the UK and the EU wanted to be. So, in other negotiations, this can sometimes come down to, the EU sometimes wants other countries to sign ILO, sign up to international labour accords, and that's a very politically sensitive issue in many countries. I don't think that's the issue here necessarily, but when we look at it from a state aid perspective, I can understand the UK's concerns in respect of a very actually recent example on state aid in respect of the coronavirus pandemic. I won't go into too much detail, but suffice to say that the ability to access the UK government's flagship loan scheme has been significantly constrained by a particular type of rule that the EU introduced around the temporary state aid legislative framework. And this particular rule, it's called the Undertaking and Difficulty Rule, effectively tries to distinguish by way of a date in December those who really need the help and those who were not justified to receive it. This has been a particular issue that banks have been relying on to say, well, you weren't in difficulty as at the end of this, you were in difficulty based on this ratio, and therefore you don't qualify for the aid. This isn't a particular issue in other countries, but regardless of that, you could see a scenario from the UK's perspective through this example of disquiet at not necessarily, even if it is a UK specific issue, how do you get your particularities as the UK government, the sensitivities that may exist because of the way our financial system or the way businesses are structured differs from other countries. And so I think that is a legitimate concern to have, that as those rules, if you were to accede to the EU's request to effectively keep adopting EU state aid rules, and that be the way in which we come to an agreement on a level playing field, that the particularities of the UK's approach would not necessarily be captured in that. Now, the other side, flip side of that, to say is, well, if the UK government, I think the EU would be much more willing to have a discussion about how the UK's participation or recognition of its unique issues as rules that it has to continue adopting are being developed, if the UK were willing to have that starting point, that the EU would be very minded to change the way in which it looks at how the UK's influence would be taken account of as regulations are being developed. But in light of the fact that the UK government does not want that, I think we're not even having that discussion. So on the state aid piece as a whole, I really think that there are ways to square the circle here. I don't think we will get there until much later in the negotiations, because we are in an nothing is agreed until everything is agreed space, as we found ourselves through the withdrawal agreement. There are some suggestions and proposals out there saying to look at, the proposals around the joint committee when the previous government was proposing to have, this question of if they aligned, could they have not so much an arbitration committee, but when there was a discussion of we think that we may want to align, and this is how any dispute over an interpretation of that alignment would work, there was a proposal, I think, from the UK side about how that would be discussed in a sort of joint committee, and then if there was an argument, potentially it could be sent to the Court of Justice for a ruling, but only at that point. These are some of the ways in which you could potentially look at squaring the circle. But ultimately, I do think that the EU's ask is much more ambitious, and it needs to, I think the focus and the reason for the contentiousness of this is because the UK government, as far as I can see, is not trying to argue that it wants to get out of this to subsidize its industries beyond what is currently provided for. I don't see that argument necessarily. And so the question becomes, I think this is why it's contentious, what is exactly the purpose of the EU's request in this context? Is it truly just about making sure that you're upholding the same types of standards, or is it just about making sure that those standards are coming from the EU? What are their concerns? The last thing I would say on that, though, briefly, is that it's important to remember that we are in a period of time right now where countries are going to be really desperate to hold on to their market shares, domestic market shares. And so I think this issue, while it always would have been one before, is going to be a particular issue now because EU countries want to make sure that their companies are not being unfairly discriminated against, or the UK has a leg up that it might not have. And I think that's a particular issue from an economic point of view in sectors like steel and anti-dumping, for example.
Thank you very much.
Thanks very much for that. I think that point regarding the market share, I thought was really interesting, particularly because of what we've heard earlier on in this session with what appears to be the UK hemorrhaging parts of the financial sector over to the EU nations, which is understandable. I'm pretty sure we can all agree on that. But on the issue of the level playing field, there clearly has been some level of convergence regarding the environmental and the labour situations. Of still some challenges there regarding state aid, but as well as the financial sector. And we know that David Frost, when he spoke to the committee in Westminster, and I'll quote him, he said, to recall, we are not saying that there can be no level playing field provisions. We're simply saying that there must be provisions that are appropriate to a free trade agreement. But understandably, from an EU perspective, Canada and Japan are further away geographically as compared to where the UK is in relation to the EU. Do the panellists think that is the driving element in this situation, also these discussions? Because of the geographical closeness, then the EU clearly wants to protect its other EU, well, all the EU 27 members.
Professor Hall?
Yeah, so we know from research that geography matters in trade, and the fact that Canada is hundreds and thousands of miles away is very different to the fact that Calais is about 26 miles away from the UK. So on that basis, I think it is understandable as to why the EU is concerned about protecting itself from what it perceives as a risk of regulatory undercutting from a large geographically proximate trading partner. And I think that is different to the risks, if you like, that it might perceive from somewhere like Japan, Canada or Australia. So yeah, I think that does make sense. I think on the specific point around financial services, one point to make is that it's quite unusual as a large trading bloc to have your kind of financial centre that serves your financial needs to be outside of that bloc. So if you think about the US, it obviously has New York as its large international financial centre, and Tokyo is performing a similar role for Japan. So I can understand why it would be seen to be unusual for the EU to have its largest financial centre, currently London, outside of its outside of the single market. And to my mind, that does make sense as to why there is interest in exploring what parts of London's financial services sector may end up being onshored essentially to places like Frankfurt or Paris.
Thank you. Ali,
Thanks,
if you want to come in?
Briefly, I agree with some of that. I do think that it's, I don't want to say naive. I have not seen the EU make this argument in previous negotiations, during negotiations, but the context is obviously very different because they were seeking access, and we've been very clear that we want the ability this government to diverge. It's important to remember the context also from the perspective of looking what has happened with the EU and Switzerland. And this goes back to another question, which is also relevant to about the sort of sweeping institutional framework versus bilateral treaties in Switzerland's case. And I think it's important to remember that the experience of Switzerland with the EU is something, from my perspective, that the EU is seeking to fix or to make sure does not happen again, because they see it's too unwieldy. Now, that has been, for many people, a control or a struggle over sovereignty and a power struggle in a sense. So, there is an example of, because Switzerland is not in the EEA agreement, is not a party to the EEA agreement. There is an example, I suppose, of a country where it has not accepted those kind of level playing field provisions. That is probably a different kind of circumstance to piecemeal integration into the single market, which is effectively what Switzerland has done. It's not been linked to a specific time, so it's hard to completely compare apples and oranges, but I would draw attention to that context because I think that very much informs the EU's approach to this, as well as there being a valid argument around does geographical proximity increase the need for those level playing field commitments generally, as opposed to how those are actually implemented and enforced. It's important to remember that both sides are not arguing about the substance here. It's about the method for upholding those commitments.
Okay, thank you very much. Elspeth has now had to leave the meeting, so thank you very much, Elspeth, for your contribution, and thank you also for offering to provide more information in writing if any members need that. I'd now like to bring in Gordon Lyndhurst. Gordon, are you there?
Thank you, convener. I thought I was being brought in. And good morning to, I think it's Professor Hall that we now have as the witness. Professor Hall, you talked about the importance of financial services to Scotland, in particular to Edinburgh, banking and asset management firms. I'm just wanting to ask, given that we're leaving the EU, and also given the negotiating positions of the party as we are aware of them so far, I'm one of these people that actually this is an opportunity for both sides to try something new and to the advantage of potentially both sides. I don't actually think that one side has to lose out of this or the other. So are you able to say what are the three or however many there are key points that you think should be included in whatever is agreed regarding financial services arrangements in whatever deal is struck between the UK and the EU, and in particular with regard to Scotland's position in Edinburgh as a financial centre?
Thank you very much for that. I think in terms of what my summary position would be, the first really goes back to some points that Ali Renison made at the start around clarity and certainty around what is going to replace passporting. It appears to me that it's clear it's going to be some form of equivalence, but exactly how that is implemented, and particularly what the terms are around potential ending of equivalence will be really critical to help firms plan. So I think some clarity and certainty around what the equivalence regime will be and how it will be administered would be central. The second area, I think, and the UK negotiating position makes a big ask on this, and I think quite rightly so, is the ability for individuals to travel to deliver financial services and related services. So this comes back to the question around the mutual recognition of professional qualifications. I make this point because I think it's important to note, and I haven't noted it so far, that financial services is closely related to a whole set of other business and professional services. And this has become an increasing feature of financial services in recent years, particularly its close links with legal services. So the UK draft negotiating position is ambitious in this area, more ambitious than the EU's current agreement with Canada, and I think rightly so, because when we think about the practicalities of how services are delivered and how client and service provider relationships develop, it is about close working relationships. So the UK is asking for the automatic recognition of these qualifications rather than a more deliberative process, if you like, that's in the CETA deal. And I think the third area where I think it would be prudent to focus attention on is on the cooperation around prudential and regulatory matters. So here I think there's a useful example that could be drawn on in the EU-Japan agreement, where they have a regulatory forum between the EU and Japan, and that seems to be sensible in terms of questions around regulatory stability, alignment, sharing information, etc. Those would be the three areas that I would like to draw attention to.
Thank you. Gordon.
Yes, thank you very much for that answer. And given the negotiating positions thus far of the parties, do you think realistically these three key objectives are achievable?
I think it's fair to say that there is still a gap in the negotiating positions between the EU and the UK, but I also think it's fair to say that it is narrower than it was before. In some ways, this leads me to a degree of optimism that an agreement could be reached. I don't think it will be reached by July as was initially envisaged. I think we'll be looking towards the autumn. But in trade negotiations, it's obviously understandable that parties put out their kind of almost maximalist demands at the start, and then it is a negotiation, and I think we need to remember that. So, for example, the UK has pulled back a little bit in terms of demanding fast-track equivalence treatment. And I think there are examples that the EU already has around some of these questions of regulatory alignment, particularly on Japan, that might be helpful in addressing that question that I raised earlier of regulatory coordination.
Thank you. Does anyone else want to come in? Ali?
Could I just briefly on that? I mean, I think it's for financial services. Let me put my video on. I'm not sure if I need to do that, but for financial services, I think there's a much more balanced set of views within industry about what the priority is here. So if you were to, for example, compare amongst our members financial service and manufacturing, there is a much bigger share in favor of alignment in manufacturing than there is for financial services. And I think that is linked back to number one, actually, at least amongst our membership, not all financial services are internationally oriented. We actually have a lower share of people, members in financial services who will trade internationally than, for example, manufacturing. So that maybe reflect that. But also, I think in terms of, whereas for other sectors, market access and relocation are all predicated on waiting to see where we get to with the UK and the EU. Financial services has not been in that position. If you remember, I think it was 2017, the Bank of England, the regulatory authorities at the UK level were demanding to know for at least listed companies what their financial contingency plannings were. And I think financial services is much further ahead in terms of relocating on that basis. And so I think it's more of a case in this sector that in terms of the outcome of the negotiations, it would be a nice to have, but it's not predicated on whether they're going to move and relocate or not, which is much more existential, I think, for a lot of firms. But interestingly, I think that speaks to another dynamic here, which is, I think we've seen the ISRG has come out with proposals previously for almost a managed divergence. The EU effectively said absolutely not. They've come back with another blueprint. I think the Chancellor wrote, and the outgoing Bank of England Governor, Mark Carney, had said similarly that they wanted to see rapid agreements on financial services. And Vasilis Dombrovskis, who was the EU's vice president, the Commission's vice president for economic and financial affairs, effectively said no, there was no deadline. I think it would be a mistake to link the outcome of all of this to what's going to happen in the negotiation. And I think that's very unusual in that respect, in the sense that while it would be nice to have agreement now on arrangements to stop this 30-day access from being withdrawn, because that would be very disruptive, it's not going to be all put into the free trade agreement. This is going to be a very dynamic process of cooperation. And I think actually my prediction would be that we're going to see more substantive engagement on this after these negotiations end, because really, I think for financial services, it's very similar to other aspects of services in free trade agreements. They often set the framework for cooperation to occur rather than necessarily granting sweeping market access. So if you look at the EU-US negotiations, TTIP, when they were ongoing, it was actually the EU pushing really hard for better improved regulatory cooperation, not so much on the market access side, because both sides were fairly open. And it was at that point in time the US administration under President Obama who did not want to talk about regulatory cooperation in the form of a trade agreement. And while those negotiations were never completed, where you did start to get to some common position on that regulatory cooperation point of view, which is different from predicating your market access on regulatory cooperation. There is cooperation for its own sake to try and minimize the aspect for difference in implementation, because at the end of the day, the UK and the EU will still be implementing at an international level the Basel III, 4, and 5 accords, but there may be some differences in implementation. So you need to have a forum to make sure that there's no unnecessary differences that result in extraterritorial application of domestic laws, whereby you perhaps unwittingly push out third country suppliers because of your domestic regulation. So creating a forum for that kind of cooperation is very important, but that is not necessarily always the same as being linked to the market access side of that. So I think financial services, when it comes to the opportunity side of it, I think we're going to see a lot more progress after these negotiations are over, simply because it's a very dynamic, you're not going to get, I don't think, a framework that says this is our market access arrangements for equivalence across the board, because effectively that's not how equivalence works at the moment. It is almost directive by directive by directive. And the last thing I would say on that, however, it's very important to monitor how the EU evolves its own legislation on third countries when it comes to equivalence, because there has been some concern that with the UK's asks in mind outside of the single market on equivalence, there has been some concern that some of the domestic legislation, or I should say some of the legislation that is being passed on an ongoing basis by the EU, may be looking at third country in a very different way because they have the UK in mind. So it may be that we get to a better outcome after these negotiations are over on financial services.
Okay, thank you very much. Professor Hall, you wanted to come back in on that?
I think there's one important point to note here, is that the financial service sector itself is not fixed and changes quite rapidly. So, for example, even since the Brexit referendum result, we've seen the emergence of important new parts of the financial services sector. So I'm thinking here about fintech, financial technology firms that have played quite an important role in some of the financing around coronavirus response. And I make this point because when we look at the history of the UK as a financial services centre as a whole, it's actually done, I think, quite a good job of innovating its way out of different economic shocks and developing new types of financial products. So the Eurobond market in the 1960s would be an example, developments around green finance or fintech. And so in that sense, I would support Ali Rennison's points that this is an area where negotiations and talks are likely to go on after the end of any agreement around a free trade agreement, particularly because of the really dynamic nature of the sector.
Right. UK is particularly strong in fintech, I understand. Is that going to cause problems? I understand from your paper that you were saying that the UK was pushing quite hard in that area.
Yeah, so fintech is an area the UK has done very well in and has continued to do well in since the Brexit referendum. I think there's the main concern, as I understand it, for that sector is access to highly skilled individuals who work in that. So that sector in the UK is quite heavily reliant on EU nationals. These nationals are not likely to be restricted in their movement to the UK at the end of transition by the changing proposed immigration policy, i.e. the salary threshold is not likely to be a problem for this group. But I think there are concerns about the kind of talent pipeline, and if that were interrupted, would we be able to substitute that with domestically trained people with particularly the technical expertise that fintech requires? So this relates to a much broader question around the extent to which the UK education system is producing enough domestically skilled people in the kind of very technical science STEM type areas that this sector needs. And I know that's something that the fintech sector itself is concerned about and interested in thinking about how it might increase the domestic supply of those kinds of individuals.
Interesting. Thank you very much. Now going on to Annabelle Ewing. Annabelle, we have a little bit of time in hand, so if you had an extra question, that would be all right.
Okay. Thank you, convener, and good morning to colleagues and to our remaining panel members. Picking up on some of the issues discussed thus far, so to Professor Hall in particular, I noted from her submission that she stated that around 67% of financials, so excluding insurance, about 67% of UK financial services to the EU are delivered from a UK base on a services basis. So notwithstanding some of the interesting discussion we've had about fintech and some asset management companies perhaps seeing opportunities in what they may hope is a reduction in regulation, it's not entirely clear from any EU rules that would be directly applicable. It still seems that the vast body of financial services at this time, and probably for some considerable number of years to come, is provided on a services basis from the UK. And obviously, if you take away the single banking licence, the single investment services licence, the UCITS rules and so forth, then that must have some considerable impact, notwithstanding whatever equivalence agreement is ultimately reached, because equivalence is not the same as the single banking licence. Could Professor Hall perhaps expand on that?
Yes, so that's the figure that I cited in my written evidence. And I think it is true that for some parts, particularly of corporate banking and private banking, they rely heavily on the passport at the moment, to use that passport to use their UK base to service EU markets. And it's also the case that equivalence even if it were granted in the 40 areas, around 40 areas that it covers, is not the same as passporting, and particularly in aspects of corporate banking and private banking, equivalence does not go as far as passporting. So I think this is, to my mind, why you've started to see financial services firms and banks in particular starting to relocate parts of their businesses into the rest of the EU single market. I think it's actually quite hard to get a really accurate sense of what the scale of this could be. That's partly because, for understandable reasons, individual businesses probably don't want to talk about their individual corporate strategy publicly. But also, I think it's important to note that the change has already started to happen and will continue to happen in a gradual way. I don't think that you would see a kind of cliff edge shift in the nature of financial services in the UK, and I think that then means that it's really important to try and track these changes in real time, because they won't be as immediate. It's not going to be a kind of overnight decline in the UK's role within the EU as a financial centre. So I think this gradual change has already started and is likely to continue.
Thank you for that. I mean, you raise a very interesting issue just at the end of your response there, I think, which is to do with where we are in the negotiations. So whether or not there is an extension, it seems from the language used by the UK that they don't want one. So if there's no extension, then is there going to be a deal? If there is going to be a deal, what kind of deal is it going to be? And therefore you say that there wouldn't necessarily be any changes in the shorter term, but the fact of the matter is that come a certain point in time, which could actually be by the end of the year, so UK banks currently based, or investment services firms perhaps more particularly, currently based in London, will not be able to operate on a services basis or even set up a branch under the banking licence or the investment services licence in any of the other 27 EU member states. That will happen if there's no deal. That's the end of that. So actually, there will be a cliff edge. There will be a key moment in time where what they can do, say, for example, on the 31st of December, they cannot do on the 1st of January.
There will be a cliff edge there will be a cliff edge in terms of what they can and can't do. I think what I was trying to emphasise was that given the uncertainties currently, they are already implementing plans to get around that uncertainty. So in terms of what we see on the ground, things have already started to change.
Yeah, thank you for that. I'm sure that planning, and we've seen that, and you've rightly said yourself, Professor Hall, that we've seen, a vast number of financial institutions moving to other European capitals, and with all that entails in terms of workforce and contribution to tax system and generating all kinds of other business and so forth down the line. So we have seen that. Of course, they're making preparations, but my point is, for those who have not done so, there could come a very steep cliff edge moment in time. Can I ask one more question to you, then perhaps one question to the other panel member, Ali Renison? For yourself, in terms of the equivalence, we still, I think, have the possibility of the 30-day withdrawal issue out there. I don't think that has been sorted yet, because that would be the normal position. And as far as I understand it, with EU international agreements, that yes, equivalence, but yes, it can be withdrawn on 30 days' notice. To your mind, has that been resolved yet, or is that still very much a live issue?
My understanding is that that is a live issue, and that you are exactly right that on a standard basis, equivalence can be withdrawn with 30 days notice. That's actually been the subject of quite a lot of interest on the UK side. Ali Redison raised the fact that different chancellors have kind of mooted different versions of equivalence. Enhanced equivalence has been used for a while, and I think a lot of that discussion is around two issues on that 30-day question. One is will it be 30 days, or might there be a case for longer, would be one set of questions. And the second, I think, is on what basis it could be withdrawn, and what the governance of that decision would be, which is why I raised earlier the example of the EU-Japan agreement, which has a slightly different governance set up around it. I think the UK is keen to explore the basis, or to get clarity on what the basis of a withdrawal of an equivalence assessment could be from the EU side.
Okay, thank you for that. And one brief question to Ali Renison, if I may, convener. Going back to the level playing field issue, and really, again, picking up this last issue about governance in general, as far as I understand it, the EU is insisting at this stage on some sort of governance structure that could result in sanctions being imposed, and the UK is resisting that proposition. Is there any intelligence on where that issue currently stands and what might be the resolution to that?
Not absolutely up to date. I think just to tie this response back in with Professor Hall's response, again, it was in March that the Chancellor wrote to the EU asking, I think to that end, because of the 30-day issue, for these to be settled, to give some kind of clarity ahead of time, and the EU's response was fairly not forthcoming, and effectively said, I think it was 4 paragraphs that said we look forward to taking account of the UK's intended divergences. And I think that's where, it's tempting to just focus on what's going on in the negotiating room. Please do keep in mind that announcements such as the previous chancellors at their party conference of drawing up a list of EU rules to consult on whether to keep or not, that impacts the negotiation, because that effectively tells the EU that there are plans afoot, whether it's in substance. We don't know what has happened to that commitment. It was the previous chancellor who announced that. Is that a government initiative being taken forward? But announcements like that, I think, reinforce the EU's point of view that as long as the government is creating any mood music, whether in the negotiation rooms or outside of them, around intending to diverge without giving that clarity, I think that helps reinforce their political robustness over this issue. But I do think it's still important to go back to what Professor Hall was saying, is in that, not that there isn't a potential cliff edge for companies, but and I'm quite happy to send this to the committee afterwards, looking at the relocation. So, for example, in the main overall, about 63% of our members have said they have no intentions, this was last year, I might add, of relocating. And then about almost 30% saying they were engaging with it in some form, whether it was they were already relocated, whether it was they were looking at doing so, they were in the process of doing so. But then you have to look at, well, what is that actual type of relocation activity? Transferring a small back office is very different to transferring staff. And so that's why you have to start looking at, well, what do we mean by relocation? And I think you have to also distinguish between how maybe domestic financial institutions are looking at this compared to overseas institutions. The UK, I think in financial services, unlike, for example, automotive, the access to the single market for overseas investors when it comes to manufacturing is much bigger, I think, as a consideration than for financial services, because of the UK's starting expertise in a number of different subsectors in that. And so, a lot of overseas investment banks, for example, whether they're Japanese or American, to some extent, some will say that they already had an investment strategy that differed for the UK and the rest of the EU because the UK is not in the euro. Some people have made that argument, and this accelerates that kind of differing approach to investment strategy. And I think it's right to say that, it's not going to be immediate. And the biggest thing I think that unites, whether it's in financial services or services across the board, as Professor Hall alluded to, that will make or break this issue is how disruptive or how smooth the arrangements to replace freedom of movement are. Because that is by far the single biggest issue that unites all of our members, is what is going to replace that and how easy or difficult will it be afterwards. So I think, while not immediately, I think a lot will turn on that as much as what the actual equivalence arrangements are.
Thank you for that. If I could just say very briefly, in terms of the back office issue, obviously, you'll be aware, as far as financial services are concerned, that a back office will not be sufficient to get the passport.
No.
You have to have a proper incorporation and a proper, not a boilerplate entity. It has to be the full Monty, and that's quite clear from EU law. The other issue I would say, I entirely agree that free movement is fundamental. But I would just make the point, it's not just free movement for bankers, it's free movement for all workers that is the key issue in terms of our economy, I would have thought.
Thank you. Thanks very much. I'd like to come in on some other aspects of Professor Hall's paper, if I may, because you obviously talk about other services apart from financial services, and you talk about an important aspect of the negotiations for services relates to the rules governing who's able to travel between the UK and EU to provide services, and it's relatively easy to do business in another member state because professional qualifications are recognised, and that would cover areas lawyers, accountants and architects as some of the examples that you give. But I was interested to see that you're saying that the UK negotiating document is very ambitious in this area, going beyond other FTAs and CETA, whereas the EU's position is rather different. I wonder if you could say a little bit more about that.
So yeah, this is one of the most interesting parts of the UK's document for me, as the submission that I made says it does try and go further, and particularly what the UK appears to be asking for is the automatic recognition of these professional qualifications. So this is who is able to practice as a lawyer, an architect, etc. I think this idea of automatic is important because that actually could be one way in which any disruption around the transition, the end of transition, could be smoothed. If there was certainty around the automatic recognition of these qualifications, to my mind, that would allow a greater degree of certainty. This is not how it works in CETA, where there's as I understand it, I think it's a sort of group that needs to look at the process of granting this recognition of qualifications. I think this is really important in the case of the UK negotiations because of the practicalities of how some of these services are delivered, and this again is different to the case of Canada or Japan, which are often drawn on as parallels. And it comes down to very practical questions that we have strengths in so-called fly-in, fly-out services, where a consultant, a management consultant, for example, might travel to Brussels just for a day to deliver a service. And I think this is important because being able to travel easily on a flexible basis, particularly when we think about services work as being largely project driven and often quite transnational in nature. So architecture speaks quite a lot about this, about how you might have an architectural project in Madrid that's drawing on architects from the UK who travel in on a very flexible and short-term basis is important. And to my mind, any kind of additional paperwork or uncertainty around those kinds of trips could lead to additional uncertainty for businesses, but also potentially additional costs in terms of meeting requirements on visas, etc. I think the other point here is that if you rely on a more national based sort of set of bilateral relationships with these kinds of agreements, it's different for every country. So every EU member state, so if you're a UK-based business and you want to send people to a number of different EU countries, you would have to be familiar with the requirements for each of those different member states, which particularly for smaller firms would add additional costs and administrative burdens, I think.
That's worrying. And I noticed also you said that the audiovisual sector, including film and TV related businesses, is one of the service sectors where the EU and the UK appear furthest apart. Obviously, this committee, as well as being the Europe Committee, is also the Culture Committee. We're very interested in that area of the economy. Can you tell us why they're so far apart and whether there's any opportunity to bridge that divide?
So they're far apart in very stark terms in that the UK wants to include audiovisual in a future trade agreement, and the EU doesn't typically include these in agreements it already has. So the difference is incredibly stark in terms of whether it's even in the agreement or not. For the EU, this comes down to rules of origin of where television and film programmes are made. And I think it's probably linked, although this is beyond the specific focus that I've done around questions of the dominance of English language broadcasting and concerns about that. It's quite a complicated regulatory area in that at the moment, programmes made in the UK have a broadcast licence issued by Ofcom, which is then recognised within the EU single market. If the UK becomes a third country, then Ofcom wouldn't be recognised under one of the kind of two main regulatory areas in this field. However, there is another piece of regulation, that came into force in the early 1990s, which would still stand. The issue with that is that it doesn't cover all EU member states for the UK, and it's much more limited on on-demand services, so things like iPlayer and those kinds of things. And that's partly because it came into force in 1993, I think it was, when obviously those services weren't in operation.
That will be very, very worrying, because it's such an important sector of the UK economy, and as you alluded to, there's quite a lot of protectionism, isn't there, in that particular area in different countries as they closely guard their film and TV industries, and there's a lot of competition between countries. We know that as we did a screen sector inquiry.
Yeah, I think, and also I should say that this is apparent in the EU regulations that I've just mentioned. One of them is due to be transposed into UK law in September 2020, and this does make some provisions for video on demand services. So it's an area that where the regulations on the EU side are changing. So it's an area where economically the UK does well, and relies quite heavily on exports into the EU. But it's an area where the EU is concerned, but also quite a technical area in terms of the regulations that are in play.
Okay, very interesting. I'd like to bring Claire Baker in here.
Thank you, convener. So we've had a broad-ranging discussion this morning, and we are some 6-7 months away from the point we're supposed to be leaving. And there's been expressions of how difficult it is to reach agreement on some key areas where the EU and the UK still seem quite far apart. What do you think the possibility of a no trade deal will be, that we could actually again be in a situation where we effectively come crashing out of the EU and have to resort to WTO rules? Do you think that is a possibility that might happen, and how do you think businesses are preparing for that? Do they see it as a realistic possibility that this would take place?
Would you like me to speak to that?
Yeah, please, as President.
Yeah. I think there is a risk that there clearly is a risk that no deal may be the outcome, particularly given the time left. And I personally actually think I'm possibly on the more optimistic end that a deal will be agreed come the autumn. And the reason I say this is really having looked at the UK's negotiating position, which I think does ask for quite a lot in relation to services, the area that I work on. And I think if there was a genuine appetite for a no deal exit, I'm struggling a little bit to understand why, for example, there is a whole chapter on financial services. And to my mind, that draft does show some of the areas and a recognition of some of the areas where impacts could be quite significant if we were to leave on a no-deal basis. I think the issue for me is that it's looking increasingly likely that this is going to go on to the autumn. And I think the closer it gets to December, and with the clock ticking, the greater the risk that the deal might not be scrutinised or has been as fully thought through as it could have been if the full amount of time had been used.
And does Ali want to respond to?
Yep. I would caveat this by saying that there is a live survey out in the moment asking about levels of preparedness, so I'm quite happy to write to the committee with the results of that when it comes back. Keeping in mind that the experience that certainly that I and that we had in the run-up to each and every potential no-deal date was that throughout it all, I would say there was a solid 30 to 40% of our members very much in the space of we cannot adjust until we know what's in front of us. And we're not going to waste any time doing that because we just, how long is a piece of string? And this is why, and one of the committee members may actually be able to correct me on this either way. It was good to see some devolved administrations moving towards giving financial support to help prepare. I think that's one of the biggest issues for companies as well, is accessing the specialist advice that they need. There is only one of me at my organization, and I cannot be a consultant for 30,000 people who have fairly technical asks for each sector. And so we were very keen on trying to make sure that the government the UK government put sufficient financial resource behind the commitment on preparation, but in a targeted way. And you look and see what other countries have done. Ireland, I believe the Dutch government and the French government have all put money into helping businesses access that specialist advice. And so that links into the issue about where we'll find ourselves at the end of the year. In terms of an answer to your broader question about how likely is the possibility of we still call it a no deal outcome. There have always been, we said from the beginning, two types of no deal: no withdrawal agreement and no trade deal. At the moment, it would be, apart from the areas that we know can be prepared for in advance, I think it's sort of easier to know when it comes to tariffs what the outcome will be, unless you are involved with Northern Ireland. I think that's the big item that sometimes is missing from some of this discussion. About 40% of our members in GB trade with Northern Ireland in goods directly or indirectly, and so the outcome of the negotiations, even on tariffs, may be actually slightly more difficult for some businesses to prepare for if they are in that space. But on tariffs generally, at least you know that this is what the UK would face from the EU and vice versa if we're in a no-deal setting versus a deal setting. But I would say that's about as much real clarity as we have, and that's still a big moving target of different outcomes for businesses to prepare for, particularly when you're trying to put money and cost and resource into this. Generally speaking, we see that in goods, the profit margins are much lower than financial services. And I think that's also, you have to bear that in mind when it comes to relocation. Not every business, A, relies on passporting, but B, also just the margins are so much bigger in financial services to absorb some of this cost and to make that decision of we're just going to relocate as an alternative to having to wait and see what the agreement is. And I think that's why financial services is a bit further ahead than other sectors. Whereas in manufacturing, no one wants to, particularly at this time right now, part with any unnecessarily financial resource if they don't know where it's going to be plugged into. And so I think you'd have to really wait and see what the outcome of the summit is going to be to have a clear idea of whether we're really potentially headed for no deal or not. Because there has been some discussion in the last few days about whether the EU will, I'm not sure it will, but whether the EU will amend its mandate because the Commission supposedly feels that they are reaching the limits of reaching the limits of flexibility that they are currently afforded within the existing mandate. I'm not sure, maybe Professor Hall has a view on whether that mandate would actually be amended at the summit, but I think it's important to recognize that on the one hand, we know that this government does not want to extend the transition period. On the other hand, we don't know we don't have a narrative coming out from government yet saying this is what you need to prepare for come the end of the year. We don't really have that clarity. We don't have a clear border operating model to rely on. And so I think the message from government, depending on how it happens with the summit outcome, because this is being seen as the last big political opportunity push, very often sometimes negotiators will be you sometimes really need an injection of political stimulus into negotiations that technical negotiators simply do not have to get things over the line in terms of substance. So we don't expect huge outcomes in terms of saying that this part of the negotiation is closed and sorted by the end of June, but we are hoping to see a clear narrative message from either side saying, this is what you need to prepare for depending on where we get to at the end of the year. I don't think we have that message yet from either side. I've started to see it from the Commission. I do think it does help that a lot of businesses, not the majority, but a lot of businesses were already starting to prepare for the hardest potential Brexit, so to speak, last year. And so, there are certain measures like, I think the more regulated sectors such as pharmaceuticals and chemicals, where there's really no alternative but to have a physical present or sort of qualified representative to access and place goods on that market in those sectors. They are much further ahead because they have been the sectors where having a physical presence in the EU has been the default way to prepare. I think for a lot of the other sectors, it's much more touch and go. So I would say that it really depends on where we get to with the summit. I am not surprised that we haven't seen that much progress over the negotiating rounds over the last few weeks. My focus is very much on what happens at the summit, and I think that will tell us how likely potential a no deal is, and hopefully the message around what to prepare for changes either way out of that summit.
Thank you very much.
I just there was time for a follow-up question.
I think there is, yes.
It was just to comment that where businesses, you speak about them having prepared plans, but those plans must be impacted by the current situation we're in, because we don't go a day without companies announcing redundancies. We've had retail closures announced and restaurant closures announced on a daily basis at the moment. The current coronavirus situation must have an impact on how prepared businesses feel for what they might have to go through. And you're right that the level of uncertainty they're experiencing when it comes to what the trading arrangement will be must make it extremely difficult.
Yes, and I think that's why, the last thing I'll say on this, I think that's why, businesses' views on the negotiations are not always as up to speed and up to date and following the negotiations as people may think. Sometimes, for example, I would say that there has been an increase in the level of requests from our members in the last month. I think that is commensurate with the level of news coverage, if I can be completely honest with you. I think it is something, particularly with coronavirus right now. I mentioned an example in agri-food. Until the businesses who trade with the EU, particularly from an export perspective, but also from an import perspective, are able to see what the lay of the land is going to be in Europe, it's hard to know exactly whether when it comes to stockpiling, it's very difficult for businesses now to be thinking about what position they're going to be in to stockpile. And that's why I think, from a confidence boosting perspective, regardless of whether it is the transition period being extended or not, we need confidence boosting messages from both sides. For example, when they reach progress on a particular file in the negotiation, whether it's a commitment to say that we will guarantee you that regardless of what happens, we will give businesses, whether it's in specific sectors or this period of time to adjust. Those are the things that businesses need, because it's not particularly helpful from an adjustment and implementation period to announce that 5 days before the negotiations are due to end. That has to come much earlier in the process to be of any use to business.
Thank you.
Thank you very much. Did you want to say anything before we finish up, Professor Hall?
No, I have one thing that I think I would just like to add is that I think one potential way forward may be for an agreement to be reached in the autumn period. And if it were, perhaps then there might be the case to be made for to have a transition to that agreement built in that maybe didn't come in straight away, or didn't come in straight away in all sectors on the 1st of January, to try and address some of these points that I think Ali is exactly right to raise around planning for different scenarios and the lack of information that's available on that at the moment.
Okay. Thank you very much for that. And can I thank the whole panel for their evidence today in what has been an extremely useful and helpful session as the committee continues its scrutiny of the future trading relationship. The committee will continue that scrutiny on the future relationship negotiations next week. On Thursday, the 18th of June, we will take evidence from Michael Russell, the Cabinet Secretary for the Constitution, Europe and External Affairs in the Scottish Government, and the time of the meeting will be confirmed as soon as possible. And that concludes the public part of this morning's meeting. I will allow a couple of minutes for members to have a comfort break before we resume in private session. Thank you very much.